Got to keep it live or lively.
There you go.
All right, well, hello, attendees, and welcome to the final keynote for the dispute resolution section of the section of dispute resolution's final keynote program during our Tech Expo. My name is Linda Warren Seeley. I am the director of the section. We want to welcome to our keynote program Mr. William Zauner of JAMS and his colleagues, JAMS Neutrals, the Honorable Gail Toussaint, a senior judge, a retired senior judge. No, she's not retired, sorry. Shirish Gupta, the Honorable Ariel Belen, who is retired, and Mr. Peter Wooden. Today, their program is called Virtual ADR Works. JAMS Neutrals share tips and techniques to help navigate the new reality. Before we start, I want to remind you that you can access all program information in the Tech Expo Hub. I will place a direct link to the Hub as well as this session in the chat window. We encourage you to submit questions for the presenters at any time during the program using the Q&A button in the Zoom toolbar. There will be a Q&A period throughout the program. If you need technical support during the program, please click the technical support link in the chat window, or you can send me a chat message with your problem. Please remember this program is being recorded. The recording will be posted in the Tech Expo Hub within the next few days. All right, so we've got about 2 minutes before we actually start the program. And I think, Mr. Zauner, you're going to be taken over for me in a few minutes. So once we hit 2:30, I will stop and I will go away, and then you can begin. Okay?
Okay, excellent.
We are bringing people in from the exhibit hall where they were having an opportunity to meet one-on-one with some of the exhibitors. So they'll start to trickle in slowly.
Shirish, as I said, I was going to be putting on my JAMS tie. So
There you go.
Oh, wow. How do I get one of those?
if you're going to go in, you got to go all in.
There you
I
go.
guess.
All right, so one more time. Hello, everybody. My name is Linda Warren Seeley. I am the director of the section of dispute resolution. Welcome to the final keynote in our Tech Expo. This keynote program is being presented by Mr. William Zauner of JAMS and his colleagues and JAMS Neutrals, the Honorable Gail S. Toussaint, Shirish Gupta, the Honorable Ariel Belen, who's retired, and Mr. Peter Wooden. They will be presenting Virtual ADR Works. JAMS Neutrals share tips and techniques to help navigate the new reality. Please be sure to post any questions you have in the Q&A button on the toolbar on the bottom. And do not forget that this program is being recorded. Mr. Zauner, take it away.
Okay, thank you. Welcome, and thank you for attending our panel discussion today. I'm William Zauner, Chief Information Officer of JAMS, and I will be moderating for our 4 distinguished JAMS mediators and arbitrators who are skilled at managing the resolution process online. They will share their experiences and success stories to help others overcome technology or mental roadblocks that they might be facing as the legal community embraces this new reality. At the end of the discussion, if time permits, we will address the questions posed in the Q&A. I want to start off by introducing our panel. For our first panelist, Honorable Gail Toussaint, Senior Judge, brings more than 30 years of judicial service in various Georgia jurisdictions to her practice at JAMS. Most recently, Judge Toussaint retired from her 6th elected term as Superior Court Judge in Fulton County. During her time on the Superior Court, Judge Toussaint served 2 successful terms as Chief Judge and played an active role in the design and launch of the Family Division, where she also served for over a decade. Prior to joining the bench, Judge Toussaint practiced civil litigation in a variety of areas, including intellectual property, unfair competition, franchise law, family law, and other general business matters. Shirish Gupta is an award-winning neutral known for his legal acumen and economic prowess, which makes him particularly adept at diving into complex financial technical disputes, including intellectual property, securities, and accounting, and class actions. Shirish is sought out by Silicon Valley startups as well as many Fortune 500 companies. Prior to joining JAMS, Shirish practiced law with Mayer Brown, Howard Rice, and Flashpoint Law. His practice focused on the areas he specialized in as a neutral: commercial, securities, class actions, intellectual property, founder disputes, and employment. Our next guest, Honorable Ariel Belen, joined JAMS in 2012 and serves as an arbitrator and mediator in complex domestic and international disputes spanning a wide array of practice areas. During his nearly 18-year tenure on the bench, he served as an Associate Justice of the Appellate Division, 2nd Department, and as an Administrative Judge of the Supreme Court, Kings County, Brooklyn. Judge Belen also helped create and presided over the Commercial Division in Brooklyn. And finally, but last but not least, Peter Wooden is a highly skilled dispute resolution professional with an extensive experience in negotiation, mediation, arbitration, and settlement of complex, high-stakes, multi-party litigation. He has practiced full-time as a mediator and arbitrator since 1993 and has served as a court-appointed special master with responsibilities for settlement efforts and/or discovery oversight in a variety of federal litigations. So once again, this session will provide insights and best practices for JAMS, from JAMS neutrals on navigating virtual ADR. So let's get going. JAMS recently completed a global survey of attorneys who frequently use ADR, and one of the key takeaways is that many attorneys have been surprised at how effective and successful virtual mediation and arbitration has been and can be. Since March, JAMS has handled over 2,000 virtual ADR matters. Positive feedback from clients has included comments about the process being secure, efficient, and as close as possible to the in-person experience. Parties were initially most comfortable using video conferencing for mediations, but now are increasingly using them for arbitrations and other hearings. The reliability of technology is and has been a top concern of JAMS ADR users. JAMS has taken multiple steps to protect security and privacy of our sessions. In addition, attorneys have concerns about managing other parties involved in the process and hearings, including their own clients, witnesses, and the other side. We're going to address some of these issues during today's panel. Okay, enough of that. Let's hear from our distinguished panel. Which of the biggest hesitations / fears you have heard from attorneys about use of a virtual ADR? And let's start with Judge Belen. Judge Belen?
Well, I think there's always been a concern about privacy, but as time has passed during this COVID emergency, and lawyers are becoming more and more familiar with the Zoom platform in particular and other platforms, I think those concerns have dissipated. There's also been a concern simply, particularly in the context of arbitration, with the assessment of credibility remotely. How can you do that? As well as the presentation of evidence. So with respect to credibility, I'll just say that it's incredibly interesting to me over time how focused one can be on this platform because there's very little distraction here. I'm looking at this screen, people are looking at me. If there's a witness up on this screen, I'm dead focused on that individual. And similarly in mediation, I was really hesitant at first, but over time I've come to believe that not only have I come to believe, but I've settled quite a few cases on this platform. Again, because there's this interconnectedness that's brought about, by focus, necessity. Like I just can't walk away. I can't be distracted. I can't, in a hearing, look at other documents or look at other people. I'm looking at people, and so it works. So those are two big concerns, I think, at first, and on a personal level, it was a simple fear of technology, which I overcome every day. But this is, after all, the new normal, and so here we are, and I'm pretty comfortable with it all. So, but those are generally the things people were concerned about.
Excellent. And Peter, what hesitations or fears have you heard from your practice?
Well, I think the largest overall fear of virtual proceedings is they're virtual rather than in person, and it's always been the case that people have felt the secret sauce of mediation and in-person dispute resolution as being in person, being able to sit across the table from the folks involved in the dispute, to be able to look them in the eye and have a conversation. And the concern right from the very first, and I did my first Zoom mediation about 2 days into the whole crisis in New York, there was a lot of skepticism that we would miss a lot because we were not literally at the table, the actual table. That concern has really disappeared in the proceedings that I've been conducting lately. So I think that hesitation and fear, as people have gotten used to the platform, has really disappeared for the most part.
Excellent. Sharish, what have you heard?
So there was the initial concern of people still ask me, do they settle as often as they were when we were back in person? And my experience has been it's either the same or more. So I don't see going virtually as a detriment or an impediment to settlement necessarily. And I'll just give you a data point. I've actually done an in-person mediation since COVID began, and we did the protocols. And it was kind of weird to be in a room where everyone is 6 feet apart and everyone's wearing masks. So it's hard to see the facial expressions. So that is something that's lost. It's harder to have joint sessions. Actually, I take back, I've done 2 of these now. And in one of them, we had to get a basketball court to fit the number of people that were going to be in that room. And everyone had their own table. And when I was reacting to people on the other side, thankfully I had my mask, so hopefully there weren't too many droplets going everywhere, but you had to talk louder. So these are different considerations.
Okay, excellent. And then Gail, what have you been hearing?
Well, so of course, credibility is one of the initial things that's raised in a preliminary discussion about this. Ariel has mentioned that can be overcome, and as Sharice has said, if you have a mask on in person, you're less able probably to determine facial gestures, etc. So there are advantages, of course, from doing it virtually. But one of the things that hasn't been mentioned, I have found, is that counsel are concerned about their clients' comfort level with this, with you as their neutral with the process. And so I always spend, either myself or our support staff, a good bit of time, even before we start the session initially, to make sure that they're comfortable with the technical maneuvers, that their equipment is going to work, that there is a backup plan. That's really important. So, technology is only as great as it is. And then when it's not great, then everyone is stressed. So it's really important to, to share cell phones, that sort of thing ahead of time so that you can reconnect if necessary. The other thing I think that comes up is a concern about exhibits. Especially if you have exhibit intensive cases. And I find that it is helpful to get hard copies ahead of time so that you can have those and be familiar. You absolutely need to have a facilitator to help with the share screen. You shouldn't be trying to present your case, I don't think, and sharing the screen at the same time. So those would be, my takeaways. But I think all of us are finding that everyone is more and more comfortable and understanding that not only is this something we have to do, but it's something we should want to do. There are many advantages to resolving cases in this format.
Excellent. Okay. All right. So from a neutral standpoint, what are some of the barriers you or your colleagues have overcome, and how was this done? Gail, let's stick with you for right now.
All right. Well, so some of the barriers, I think, are instructions. So it's really important that everyone be clear, start times. I like to set out a pretty clear schedule that we know we're going to break, when we're going to break, so that everyone can kind of plan their day. If you're, for the most part, either stuck in your office or at home doing this, and you want to be able to be comfortable and know when you can move about. So I think that's important. And I think practice is already alluded to. It certainly would behoove everyone to try out your volume, get your lighting, all of those things that are going to enhance your presentation and your ability to connect and interact with everyone involved in the session.
Excellent. Okay. Ariel, do you have some barriers that you've had to overcome as well? And how did you go past those?
Well, for starters, I have to remember, to turn off my mute. But, no, I think initially some of the things that Gail mentioned, in terms of exhibits, right? And I think a lot of this gets handled with very focused pre-conferences, in the arbitration setting and even in the mediation setting. And you're asking people to create binder books, which, historically has been the case any which ways, but in this instance, you got to make sure every witness and every lawyer, every participant has one. I think to the extent, some of the larger law firms are able to use outfits like Veritech to assist in the hearing itself, that overcomes some of the technological difficulties. One little thing that I've been writing into some orders actually is, I should have the ability at the time of the hearing to ask any witness to, take their laptop or whatever video device they're using and do a 360 of a room so that I can make sure that there's no one there, because that's always a difficulty and a concern that people have around, obviously, sequestration historically, confidentiality, privacy, and such. If you have a stray cat, that's okay, but people wandering in and out of rooms is not such a great idea. No, I think I say, with over time, out of necessity, quite frankly, this has actually become a pretty good way of doing things. And if you consider the savings of time and of expense that this platform allows, I think it's tremendously helpful. Yeah.
Excellent. And then Peter, I know that you do a lot of mediations. clearly there's some barriers with that as well.
Well, the largest barrier really that I had to overcome was just fear of the manageability of the platform, more specifically. As I already alluded to, doing a fairly simple two-party mediation a day or two into this, the whole shutdown. But about maybe a week or two later, I had a very complex case. It was an insurance coverage case involving maybe 12 or 15 parties. I had, I think at one point, 30 people in the mediation in a half dozen breakout rooms on several continents. The time difference was obviously required some close attention because I had folks on the West Coast and folks in Europe. But it was just the fear of being able to manage that number of people moving between rooms and setting up caucuses and having breakout sessions with different groups of parties. That was that was very nerve-wracking at first. But what I found is, as I think everyone else has already alluded to, that as you've practice makes perfect, or at least makes better. You figure out how to do it, and it becomes second nature after a while.
Yes, yes, yes. There was a lot of that for sure. And then Sharish, did you have any barriers that you also had to overcome as well?
Sure. I'll highlight two. One, I think many Americans are facing is Wi-Fi issues at home, and serious bandwidth crunches. I have two high school age kids, so during the daytime, four of us are intensive internet users because we're all using video conference. So I've upgraded my Wi-Fi network. And that took a little bit of doing because you're sometimes laying cable throughout your house and putting hotspots here and there. Also got a MiFi device as a backup. So if for some reason our home internet is down, I can use that as it's not a great backup, but it's something that will work. And then the other issue that the folks here touched on was the unfamiliarity with the platform. And that's been overcome two ways. One is, I can't say enough about how well JAMS has trained us over the past few months on how to use Zoom. We've had training after training, and we've had drop-in sessions where you can practice the skills with others. And then now what we in essence do is in our pre-hearing calls, I'll in essence do a virtual training, and I'll say, okay, to the lawyers, let's go on Zoom. Let's start it up. You share your screen, go document by document, and we'll go through some of the functionality. So the JAMS Institute trained us, and now we're training our clients.
Excellent. That's great. Okay. So what steps are being taken to protect security and privacy during a virtual mediation or arbitration? And Sharice, let's stick with you for this.
So I know at JAMS in particular, all of the sessions that we have a passcode, plus we use the waiting room feature. So it's here's the funny thing is, it's so secure that if for some reason my Wi-Fi goes wonky and I get kicked out, I can't get back in. I have to call in to our tech support, and we have people designated and dedicated to doing online sessions. So I text them and call them and say, hey, I got kicked out, and they're like, fine, we'll let you back in. So I've been really impressed at the security and never had an issue.
Excellent, excellent. And then Gail, what do you do in your sessions for protecting that security and making sure that everybody feels comfortable as well?
Gail,
Gail,
you're muted.
See, I was listening to you, Ariel. Okay, thank you. So what I was saying was we always do equipment checks. So we also need, I guess, to do mute checks. But seriously, we make sure that everyone's equipment is working well. Just by way of an example, this week I was in a multi-day arbitration with a self-represented litigant who was pretty concerned about security and wanted to use his own equipment. So we agreed. This was actually a hybrid. We'll talk more about those a little later. And so he brought in his equipment. We were all socially distanced using Zoom because there were people not in the room that needed to participate. And of course, as Charisse has mentioned, there were issues, technical issues with his computer. And so we were able to provide him with a secure, JAMS computer. No one else had access to it. He felt very comfortable and we proceeded. I think another aspect that's important is to know that the recording function on Zoom is disabled. Has been throughout the last several months of our sessions. Nowadays, I think if the parties consent and get a record, it can be recorded, but generally, there isn't going to be a recording of what's occurring, and I think that's very important, especially in a mediation.
Excellent. And then Ariel, you alluded to making people take their camera and go around the room. Are there any other security features that you are using or that you are requesting as your arbitrations are going on?
Well, I kind of reiterate what both Charisse and Gail said with respect to JAMS security protocols and the way that Zoom has been, I'll just use my terminology, super protected against bombs and breaches and access to people who aren't supposed to be there. One thing I will say is that in the past, I didn't necessarily carefully review the mediation agreements that were going out, but more recently, I want to make sure that who's ever going to participate has signed the mediation agreement or an arbitration agreement. The things that are sent, the invites are very detailed with respect to who can access these sessions. And I'm, hard to do in like Peter's situation with all those folks, but I'm sure it happens. You need to find out, who's actually there and who has permission to be there. I think part of it is you can't get on, right? If JAMS's management hasn't invited you. So, I'm actually very comfortable using this platform for all those reasons.
Excellent. Okay. So what type of training or support is offered by JAMS in order to ensure the confidence and comfort in using the virtual ADR environment for the neutrals as well as the clients? Peter, do you want to talk about that a little bit?
Sure. We've already, Sharish has already mentioned, I think it was Sharish, has mentioned the JAMS Institute and the many training sessions that were made available to us in the early days to get us up and going, and practice sessions and dry runs and all of that, because it was pretty intimidating at first, the prospect of trying to replicate what we do in person on the web and on a platform that most of us had no familiarity with. In terms of clients, JAMS is very proactive in the sense that, and I always recommend this at the preliminary conferences I have, that JAMS will, at the party's convenience, run a practice session, a 10 or 15-minute practice session to make sure that everyone's equipment works properly, to make sure that people are familiar with how to get into the meeting, what to do if they get out of the meeting, and how to move about in the meeting. And in the early days particularly, it was enormously helpful because we were able to begin the mediation at the time we were scheduled to begin, rather than spend the first 20 minutes sorting out the difficulties and trying to acquaint people with how to work. So I strongly recommend for folks who haven't spent much time on Zoom that they avail themselves to that opportunity that JAMS offers.
Great, great. Gail, I know that we have many areas around the country that are doing this. Do you have any other training or support that happens in your neck of the woods?
Well, not sure quite how to answer that, but I would say that JAMS, I think, is a standout in the concept of having dedicated as well as cross-trained staff members who are able to facilitate and stay with you throughout the day, for the process. So I think that's incredible support. Once again, the neutral doesn't have to worry about everything going smoothly. Your case manager and or your IT, professional is there to start the meeting, to help people go in and out of break rooms, to bring up the exhibits, and to fly spec any oops that occur during the day. And I do think that is unique to JAMS, but it certainly is one of the things that I rely on for a quality session.
Excellent. Okay. So on to our next question here. JAMS and many other legal organizations have frequently been using the Zoom platform. Are you using the platform most often? And what are some of the key advantages? And let's throw this over to Sharish.
Sure. So as background, I teach at law schools, and back in March, I was teaching at UC Hastings, and within a span of a week, we had to go completely virtual. And their platform of choice at the time was Microsoft Teams. So over the course of, I'd say, 6 or 7 weeks, I got very familiar with the capabilities of Microsoft Teams. And then it seemed like the default within the ADR industry was Zoom. So we got trained there as well. The vast majority of people are using Zoom for mediations. You can use Microsoft Teams. There are other platforms as well. WebEx is one. Google Meet is not so functional for this. I think overall big advantage of Zoom is its user interface and its functionality. Teams has some of the same functionality, but it looks like it's designed by coders for coders. And I say this with much love to Microsoft because I have friends that work there. But it's not as intuitive and not as easy to jump around between things. And I'll just tell you, I love the share screen function. I use it all the time in most of the sessions that I'm in. If the parties aren't sharing the screen, I will share the screen, especially when they want to talk about a certain document and they choose not to share it. I'm like, what? Like, why? Let's just throw this up there and let's just get me to that section that you care about. And then they say, well, jumping to another document, let's get that document up there. There should be, we should all be focusing on that section. And it takes advantage of people who are visual learners and auditory learners. So that way we can follow along. So hopefully you saw me sharing the screen as opposed to just
Yes, we got that.
Okay. So I think that's a huge advantage. And then also with the remote control feature, when you're sharing the screen, I'll often open up the exhibit and give the attorney that's speaking the remote control and let them move around that doc. So those are some functionalities.
Okay, great. Ariel, do you have some that you find advantageous for the Zoom environment as well?
Listen, I've been doing this for 8 years, JAMS now, and I've had calls, from people in Europe, people in California, you name it. And the best I could do historically on these types of conference calls was to try and Google a person's picture so that I can have some sense of who's talking to me over the phone. And particularly in complex cases, both mediations and arbitrations, it's really hard sometimes on the phone to, follow who's speaking when. I now do all my conferences, status conferences, preliminary conferences, oral arguments by Zoom. And it's actually mind-blowing to me how much more efficient this is to be able to see people, interact with them. So I think that's, I think the question is, what's some of the advantages of this process, and that for sure is. I want to kind of echo, I think Gail may have said this, you really should try and get some practice sessions done, or have a practice session before an arbitration, so that people, because not everyone's familiar yet with the platform. They should be familiar with what Sharice just said about share screening. I mean, that's a tremendous way of getting information across. Last thing I'll say is that you do have, at least in the JAMS, environment, a moderator, an IT person who's actually always available, if not present the entire time. So that's, that's just really golden in terms of the process.
William, we're having trouble hearing you. We see your lips moving, but
Gail, can you hear me?
Now we're good.
Okay. Gail.
You're very faint, William.
Okay, are you calling on me, William?
I'm calling on you, Gail.
Oh, okay, all right. So a couple of examples, similar to Sharice, I also am an adjunct law professor at Emory Law. And the course that I teach is actually a trial technique class, very intensive, and it's on your feet. And you're supposed to be interacting, going from beginning to end, pretrial conferences, arguments, verdicts, everything is, was supposed to be live, and then COVID hit. So we actually spent a lot of time and were able to convert the final trial with real judges and the students all on Zoom. They were all scared to death, but it was a huge success, maybe one of the first full trials actually in the country. But we were able to do it. The students learned so much, and we assured them they're going to be so far ahead when they get their job offers, and they have, done a trial. They've done exhibits, they've cross-examined, and I think one aspect of Zoom is the speaker view. It is very conducive for doing direct and cross-examination. So there are lots of ways to use the platform to your advantage. One other point, I have had some experiences, I'm sure many of us have, with self-represented litigants. And I think one way to make them comfortable using Zoom is to encourage them, to prepare their outlines, et cetera, as a PowerPoint. I had this done this week, and it really helped him. He also had English was not his first language, so there were lots of barriers, but he was able to get through it and do an amazing job using a PowerPoint through the share screen function.
Excellent. Okay, so Peter, do you find any advantages with using the Zoom environment?
Well, maybe. Yes, absolutely. Truth be told, I really enjoy the Zoom platform for mediations. I've found it has very successful in replicating the in-person. The one significant advantage is that people don't have to travel a day to get to my office to mediate with me, and then carve out that second day, and then carve out a third day to return to wherever they came from. We can do it on the day of. People are in their homes and offices, and they can sit at their desk and they can participate fully in the process. And when I'm in another room and they're not talking with their colleagues in a caucus, they can turn to other things. And so I think there's a sense among participants that it's it frees them up in ways that sitting in a small conference room at JAMS for a full day prevents them from doing. So I think, and as a consequence, I get a lot more client representatives at the table. I get folks who just couldn't afford to take a couple of days out of a calendar to come to New York to mediate, and they're fully able to participate. Senior business representatives of a client who ordinarily I won't see at a mediation, or there'll be a voice at the end of the phone. There they are at their desk and fully participating. I get a chance to work with them. And I think that probably is one of the biggest advantages of the Zoom platform.
Oh, excellent. Those are all great.
Bill,
Those are all great advantages. Thank you very much. Sharish, what other platforms, you were talking a little bit earlier, what other platforms have you found to be effective, and why?
I think we've covered that with my discussion of Teams. I think there are some groups or some people that are using Teams for mediations in part because I think some enterprise customers may already have Teams licenses, are trained on using Teams. So I think that's probably the second biggest platform that's used, but I don't think it's anywhere near the level of Zoom.
I'll just chime in, Bill, if I may. I've found that in the early days of Zoom, there was a lot of press about people intruding in meetings and disrupting them, and criticism of Zoom's security functions. That has all been addressed in part because Zoom had originally, or at the time of COVID, had disabled, or as a default, the various security functions to improve accessibility. They changed that, and now, of course, they're all enabled by default. But there are still companies that won't permit their representatives to participate in a Zoom proceeding for security concerns. And I did one a few weeks ago in which I had one party in the Zoom and the other party on, I think it was WebEx, and I was going back and forth between Zoom and WebEx all day long. It was quite inefficient, but that was the policy of the company.
Yeah, and I think at the end of the day, like, we're platform agnostic. We use whatever platform works for our clients. So if there is a newer and better system out there, which, given what's happened with Zoom stock, I'm sure there are people trying to develop that as we speak. We'll see how the industry goes. And I think,
I'm fine. So, go ahead, Trish. No, I'm sorry, I interrupted.
No.
All right, I was just going to say, so I was appointed by the Chief Judge of New York to commission to imagine the future of the courts because of this entire COVID crisis. And the commercial division in New York had been using Skype as well as some other courts. And, it's just not the same, right? The connectedness, for one thing, is not the same. Now the courts are going to Teams, and I don't understand it. I think actually, I forget either Sharice or Peter just said it's because initially Zoom had these security concerns, but this is like so far better than those platforms in my experience, no doubt. But like you said, if somebody wants to insist on that because that's what their company wants, that's what they have, and that's what we'll do. So.
And we're trained on multiple platforms, so we can pivot.
And it's all about access, access to being able to resolve the dispute. So, obviously the audience that we're speaking to today probably is not an audience that wouldn't have access to one of these platforms. But I'm really proud of JAMS for its commitment to making sure that individuals in the community that may not otherwise have access to being able to resolve their disputes can do so with the support of our organization, and I'm sure with Skype or whatever they need to do. We probably aren't going to be able to do it on FaceTime, but we can work around.
Yeah,
If that's what someone needs, we'll figure it out.
we certainly have a wide variety of choices at JAMS. This is for certain. So a little bit of a change here. Let's talk a little bit about the hearing preparation from the tech standpoint. And the question is, what is the most important thing you think neutrals can do to make the hearing go well? And let's start with Ariel on this one.
I think, traditionally, both in mediation and arbitration, you have a pre-mediation conference and arbitration a pre-hearing conference. I mean, you might have quite a few of those, particularly in arbitration. But before the session is going forward, like a week at least before, you really got to, talk about nuts and bolts, like who's coming, what platform are they using, have you tried a practice session, because JAMS will make that available to people. Do you have like a tech support person with you? Like I said earlier, in the context of arbitrations and recorded hearings, it's Veritech, in my experience, has been very helpful. But there are a number of vendors out there who can help folks. It's really getting to the nitty gritty about like what exhibits have been exchanged in what form. Does every witness attending this hearing, every lawyer, have a binder book that's base numbered that includes all exhibits that everyone's agreed as being part of the joint record, and separately that they've not, so that when a lawyer is remotely doing a direct examination of a client, for example, and certainly cross-examining somebody, he can just say, I want you to turn to Bates page such and such and look at this exhibit, right? And or put it up on a screen. But I've found, that just having that physical book shared by everyone puts everyone on the same page, makes things move smoothly, because not everyone knows how to share screens so effectively. So I think it's like everything in litigation, really. It's preparation. Back 1,000 years ago when I was a trial lawyer, I really believed like however many hours I put in advance of a trial, that's how good I was going to be. It's kind of the same thing.
Okay, thank you. Sharish, what do you think the most important thing it is that you could do to make that hearing go well?
So I'm in complete agreement with Ariel here. Once you take care of the technical stuff of how's your audio, how's your video, how's your lighting, after that, it's have you really thought about your case? Do you have your negotiating strategy ready to go? Or if it's an arbitration, do you have your witnesses lined up? I mean, one difference in my Zoom arbitrations is we have a schedule of, what's the order, who's going to go when, and they don't have to wait outside. They wait in the comfort of wherever they are. And they just get a heads up maybe 10, 15 minutes before they're ready to go when we need them. And then they just magically show up, which is, I love that part about it.
Yeah.
Yeah, so that's good.
Excellent. Okay, Peter, do you have anything here for what you think is the most important thing that you can do to help?
Well, I'm as Sharish was in agreement with Ariel, I am too. I think that's really the key, is to make sure that everyone has spent the time necessary to ensure that that from a technical perspective things move smoothly, and from a process perspective. I think probably one thing I do is I spend time at the practice session. I enjoy participating, if I have the time, in the 15-minute practice session with counsel and client representatives, anyone who's at the session. It's a way to begin to actually interact with the folks I'm going to be mediating in a much less stressful situation. And if I haven't done it there, I spend probably at least 5 minutes at the very beginning of the session with the good mornings and the introductions, going over the key logistical parameters of the Zoom conference, so people understand, if they haven't had a practice session, exactly what they can expect. And most importantly, I make sure that everyone has my cell phone number. And I have the cell phone number of one person in every breakout room, because as I tell everyone, the cell phone is the ultimate backstop to things going wrong with the internet and the technique, the logistical stuff.
Excellent. Okay. Gail, do you have anything here for what you think is most important?
Well, if we're talking about arbitrations, I think we do need to talk about the court reporter. And I think that you need to carefully select who is going to take down your record. I've had experience since we're virtual with the court reporter not even necessarily being in the same state. So we, need to make sure that the court reporter is comfortable, that you've kind of gone over these logistical matters with the court reporter in advance, so that you don't have to start and stop during the hearing. I did have this experience of having to go through 3 court reporters in one day because the first court reporter was not prepared to take down a party who had a dialect that they were not comfortable with taking down. And so you can imagine that I was concerned of not compromising the integrity of the hearing by interjecting the person's dialect as being, an annoyance or whatever you might want to call it. So that court reporter was replaced, and we got a second one who was much more efficient, and ultimately needed to get one to be in the room with us. So you just need to make sure that the court reporter is comfortable with doing this virtually and can, provide the service that's needed. If you want real time, if you want, end of day transcripts, all of those technical logistical matters need to be addressed. I don't know quite where to inject this, William, but I do think that one of the most important things that the neutral can do to make a hearing go well is to relax him or herself and to inject humor. Because I think when people realize that, you're comfortable with them and you're comfortable with the process, and if a mistake happens, it's not the end of the world, it's going to make a big difference.
Yeah, Gail, thank you for that. That's a really important point there. We're speaking a lot about the technology, but really the human aspect of that is really, really important part of this whole situation. So that's fantastic. I've seen a couple of Q&A questions that have come up here from the audience, and I kind of want to wrap it around this next topic here a little bit. There was one question that says, please discuss how your tech assistant interacts and works with the participants during the mediation arbitration. And then is there a separate fee associated with the technical assistance? And I'm going to let the panelists talk about the first one in the next question. But the second one is that we have not raised rates for this technical assistance. This is part of our white glove service at JAMS that we are always striving to do and make sure that our clients are as successful as possible during their sessions. So with that, let's go on to tech issues, which kind of fits right into this, where some people have no sound or no video or internet connection. How do the JAMS virtual ADR managers come into play during these sessions? And let's start with Peter and go with one of his anecdotes here.
Well, most critically, Sharish has already mentioned, if you get knocked off out of the meeting, you need someone who can let you back in. And JAMS assistants and moderators are always standing by and available on instantly to, and they have the technical wherewithal to get back into the meeting themselves and then permit you to come into the meeting. An odd quirk of Zoom, and it happened to me in my very first Zoom mediation, was I got knocked off the internet. I couldn't get back in when finally, since we were still working out the support options, I got back in, and I learned at that point that when I was knocked out, one of the participants was made the host of the meeting, which is how apparently JAMS prevents the meeting from completely collapsing. It took me aback. It took this particular attorney aback a little bit, I think. But it's all sorted out now, and as I said, JAMS is very quick to step in with assistance at a moment's notice.
Great.
Yeah, and on that point, I usually tell people in advance that if for some reason I get kicked out, the host will transfer to one of you. So don't be surprised by that. And I'll text you to let you know that I've been kicked out and I'm working on getting back in. Another one of the technical things that is I got a new computer just because the other one I had was 8 years old, and for video conferencing, that's a dinosaur. Yeah, so you need one with a good graphics processing unit. And I have not gotten kicked out since I got the new computer. So I think that was the problem.
As an IT guy, I'm all in for always be getting the newest stuff. So great.
Actually, what happened to me the second time I lost internet was in the hurricane that hit New York, and the internet went down. I had no power for 8 days in my house, and my MiFi expired the next day, and I was sitting in my car to recharge it, and my computer. But there's not much you can do when you lose your internet. Sharish has already mentioned he has a MiFi too as a backup, but that only lasts for a certain amount of time.
So the facilitator is part of the meeting. It, has video off, but you can see the name of the person that is there, and they're listening, and that's really important. I've found that if there's an issue with the volume, or if one voice is freezing up and it's not really apparent to me, maybe initially, they're listening. It's kind of like a second pair of ears to make sure that a good record is being created. One kind of anecdote to this is with a hybrid, and by hybrid I'm meaning that everyone that is participating is not necessarily all away on Zoom or in the room. So you have some combination. And so we learned through our first day of our hybrid, we were planning for everyone to use their own microphones. Some had earbuds, some didn't, but we were getting a lot of feedback. And so the way we resolved that was to actually bring a speakerphone into the room and put everyone that was participating on mute. Since everyone that we needed to hear was present, we could hear each other. But for purposes of the court reporter and the recording, it was helpful to use the speakerphone and have everyone on mute. So just tip to the wise there.
William, just a clarification, because I'm not sure how clear it's been in our discussion. I think kind of the evolution of JAMS is that for mediations, by and large, mediators are sufficiently experienced and don't have the procedural challenges you have in arbitration. So I think as a general practice, most of us who are mediating conduct our own mediations, and we have a moderator who begins the meeting and is always available if necessary. But I think the general practice for arbitrations is there's a JAMS moderator who is actually present in the meeting throughout the day to be able to lend assistance and moving between rooms and screens and so forth. I think that's the way it's evolved.
Yeah, I think that's a good point. Yeah, that's my experience.
Yes, yes. And again, JAMS has spent the time and effort to bring in others to help to make sure that we do cover those arbitrations and have enough coverage for all of the mediations and arbitrations that are going on throughout the day and throughout the week. So we clearly see this as an ongoing business opportunity for us, as well as a way forward for not just for COVID, but going forward from this time forward as well. Ariel, I don't want to leave you out of this. Did you have anything with the tech issues or virtual ADR managers coming into play with your sessions?
Yeah, I mean, people drop out for various reasons, but as everyone said, and Peter just mentioned, a couple of things. I think I always try and put together some form of joint sessions and mediations. Back in the day when we were together, back in the New York JAMS office or whatever, I would try and manage that, and lawyers may or may not present it, but it was just a way of getting everyone in the same room, even if they hated each other's guts. But sometimes if they hated themselves too much, it was counterproductive, so we wouldn't do that. But in this setting, you know, just to make sure everyone's here, give them some ground rules. What are your cell phone numbers? If you get knocked off, we'll come back and get you. And I just got to say, you know, I do a fair amount of coverage, you know, work, insurance coverage, and construction. And it's, you know, interestingly, and I had some construction mediations that are finally coming on board through Zoom, but they've been arguing about going, you know, to the JAMS office. And, you know, if the clients insist, I will do that. But to Sharisha's point, I haven't had to do it yet. And I don't really like the idea of wearing a mask all day, right? And I don't know how you assess credibility doing that in a hearing, an arbitration hearing. And I've had one case that, you know, after years on the verge of settlement with about 3 or 4 parties, a complex construction delay case, you know, with millions at stake. And I didn't want to do that by Zoom. Personally, I was kicking that over thinking, oh, May or June, whatever. But, you know, I've been able to do it on this platform. So I think it's really, really, really good. I think it works, and it saves a lot of time, a lot of trouble for people too, in terms of getting to these things.
Great. So as I said at the top, we've had a lot of great feedback from our clients as well as our neutrals. One neutral in Boston has had all of our online mediation settle. And so we're seeing this format be super effective throughout not just the Northeast, but all throughout the United States and all throughout JAMS for not just the mediation and arbitrations, but all of our different hearing formats and everything, all of the different types of cases that have been coming up. I've noticed that a lot of these stories have come in with a lot of different case types and as the hearing formats as well. And we're seeing just a tremendous amount of success also with your help as well. So we're almost out of time, but I do want to open this up a little bit and see if you guys have just a quick virtual ADR success story that, and I'll open it up to whoever wants to throw in a virtual ADR success story at this point.
Can I
Well,
answer?
not sure if a 5-day prediction resolved in 3 days is success. I thought that was great. I don't think that this format forces people to feel rushed. I think we have as much time as you need. But I was very pleased that a very difficult hearing actually was resolved in fewer days than estimated.
Yeah, I'd say that's a success.
If I could just answer a different question. I've been seeing things on the chat and the Q&A about technical stuff, equipment-wise. So if on my website or on my blog, I posted something about we're all YouTubers now because we're all on camera. We have to engage. So I'll just give you a couple of things. So like, for example, I went out and got lights. This is what I look like without the lights. So it's a big difference. Also got a fancy microphone just because it's important that you be able to hear me. Have the webcam, got the new computer, got the video, the Wi-Fi equipment, upgraded that, and the screen, bought a much bigger display so that way I can see everyone, see the docs. And there are times when I second screen it. So if you have the new iOS or Mac OS, you can second screen on an iPad. So you can extend desktop to an iPad that you're not physically connected. There are some neutrals that have 2 physical monitors or more. If you have some time, just go on Twitter and look at some law professor setups. Some people have gone to the extreme where they have like 7 monitors, all this lighting, and we are not there. 1 to 2 monitors is plenty. Okay.
I just got a book and some books in a bookcase here, but other than that.
I know that some folks who are doing a lot of arbitrations like a second screen for documents specifically, so they can divide up, people on one screen, documents on another.
Makes life a lot easier. Yeah.
Okay.
All right. Well, That was fantastic. Thank you guys so very much. Really enjoyed your presentation today. I think it was very helpful to many of our members. This is Linda Warren Zeeley. I am the director of the section of dispute resolution. Many thanks to Bill Zauner and all of his JAMS colleagues for a great program. For the attendees, if you will check in the chat, you will see a link to the evaluation of this particular session. And you will also see a link to the very next program that we've got coming up right now today. And it's called, Are You Ready to Become a DDRS? ADR, ODR International will discuss and examine why the future is around digital dispute resolution and how it is best placed to provide the qualifications and infrastructure for the future. So this will be our last formal program today. We do have a tour of the Whirligig Brewery at 5 o'clock and a happy hour at 5:30. So join us for that. And again, many thanks to the JAMS Neutrals for a great program. Really enjoyed it.
Thank you. Thank you.
Thank you, everyone.
Thank you.
Thanks, Bill.
Enjoyed it.
Take care. Bye-bye, everyone.
Bye-bye.
Bye.